Hello everyone, welcome to Crystal Diaries. This is another video of a series of videos relating to law of contracts in India. So today in this video we are going to read about privity of contract with some important case laws. But before we begin, please bring your Bayer Act, a notebook and a pen so that we can read the Bayer Act simultaneously and note down all the important points whatever we discuss here. So, let us begin. Doctrine of privity in contract. So, the doctrine goes as a contract cannot confer rights or impose obligations arising under it on any person or agent except the parties to it. So, this is an English common law doctrine, and this in layman's language it means that no stranger or no third party to a contract can sue in case of breach. In our previous videos, we have read about the essential elements of a valid contract. And we had read that in a valid contract, there are two or more parties to it. And in case any party breaches the contract or restrains oneself from doing one's obligation, then the affected party or the aggrieved party can sue. But no third party, a person who is not at all a party to a contract, cannot sue in case of breach. Let us understand this with the help of an illustration. So, if A makes a promise to deliver goods to B, then in this case, if A breaches the contract, then only B has a right to prosecute him and no other person can prosecute him. Now let us quickly understand the essentials of privity of contract. As you can see the slide, there are four essentials of privity of contract. The first one is the contract has been entered into between two parties. And the second one is parties must be competent and there should be a valid consideration. So it tells about two things, that the parties must be competent. Who are competent parties? I have discussed in the previous video. You can check them, that they must be major, they should not be of unsound mind, and they should not be disqualified by law to enter into contract, and there should be a valid consideration. Valid consideration means a lawful consideration. Then the third one is there has been a breach of contract by one of the parties. So there are two parties in a contract and one of them has not fulfilled one's obligation. And the fourth one is only parties to contract can sue each other. So these are the four essential elements of privity of contract. Now let us look at two important case laws relating to privity of contract. So the first case law is Twiddle versus Atkinson. As you can see, in this case, there is a groom and there is a bride. And each of the father, that means the groom's father and bride's father, have got into a contract. So the facts of the case is that the son and daughter of the parties involved in this dispute were getting married. As such, the father of the groom and the father of the bride entered into an agreement that they would both pay sums of money to the couple. But the father of the bride died before he paid the money to the couple, and the father of the son also died before he could sue on agreement between the parties. As a result of this, the groom brought a claim against the executor of the will for the payment that was previously agreed between the fathers. So what was the issue here? The issue for the court was that whether or not the son could, as a third party to the contract, because the agreement was between the two old men. But what is the son doing here? That son is a third party in this contract. Can he enforce the contract between their fathers, which was ultimately for the benefit of him and his wife? So what it was argued that the intention of the agreement between the fathers was for the couple to derive a benefit from the payment of money. Also, it was argued that preventing the son from being able to enforce the contract would effectively ignore the intention of the fathers. But what did the court hold? The court held that the groom's claim was rejected by the court. It was held that the groom was not a part of the agreement between the fathers and he did not provide any consideration for promise made by father of the bride. Also, as a stranger to contract, the son could not enforce it. On this basis, the court found in favor of the executor of the will. So as you see here, the son was the third party, and by using this doctrine, he could not sue anyone in this contract. So let us discuss another important case law, and the name of the case is Chinnaya versus Ramaya. So in this case, there was an old lady. She gifted a property consisting of some land to her daughter, who is the defendant in this case, by a gifted. And there was a clause in the terms of the deed that the daughter had to pay a certain amount of money to the lady's brother. So what happens? The lady dies, and for quite a few days, the daughter pays some amount of money to her maternal uncle. But later on, she stops from doing that. Therefore, the plaintiff here, who is Chinnaya, or that maternal uncle, sues the defendant for the recovery of the same. Now, what is the issue here? The issue is whether the plaintiff can bring an action against the defendant for the amount promised in a contract, but the consideration for such promise has been furnished by the mother of the defendant or the plaintiff's sister. So, what happens here? The girl says that me and my mother had a contract. We don't have a contract. That you, the maternal uncle and the daughter do not have contract. So, what happens? Can the uncle, who is not giving any kind of consideration, can he sue? So the appellants argued that the consideration for getting the property was a promise to pay the amount annually to the plaintiff. But the respondents argued that the plaintiff was not a party to the contract, hence he has no right to compel the respondent for paying the promised amount. But the court held that the defendant and the plaintiff and the consideration has been furnished on the behalf of the plaintiff, who is the sister, by her own sister or the respondent's mother. Although the plaintiff was stranger to the consideration, but since he was a party to the contract, he could enforce the promise to the promiser, since under law, consideration may be given by the promisee or anyone on her behalf. If you read section 2D of the Indian Contract Act, you will find this thing. So these are the two important case laws. Now let us go and find out what are the exceptions of the privity of contract. So as you can see in this slide, there are 6 exceptions to privity of contract. The first one is trust, family settlement, assignment of a contract, acknowledgement or estoppel. 5th, a covenant running with the land. And 6th, contract through an agent. So let us understand all this one by one. So the first one is trust. So when we say trust, let us understand this by, if a contract is made between the trustee of a trust and another party, then the beneficiary of the trust can sue by enforcing his right under the trust even if he is a stranger to the contract. Let us take an example. Suppose A's father had an illegitimate son, B. Before he died, he put A in possession of his estate with a condition that A would pay B an amount of rupees 5 lakh and transfer half of the estate in B's name once he becomes 21 years old. After attaining the age, if B does not receive the money and asks A about it, he denied about giving him the share, then B files a suit for recovery. Now the court holds that a trust was formed with A as the beneficiary for a certain amount and share of the estate. Hence B has the right to sue upon the contract between A and his father even though he was not a party to it. Now the second exception is family settlement. So if a contract is made under a family arrangement to benefit a stranger means a person not a party to the contract, then the stranger can sue his own right as a beneficiary to that contract. Now let us understand this with an example. Suppose A promises B's father that he would marry B, else he would pay 50,000 rupees as damages. but he marries someone else, thereby he breaches the contract. Now B files a case against A, which was held by the court since the contract was a family settlement with B as the beneficiary. Now the third exception is assignment of a contract. If a contract is made for the benefit of a person, then he can sue upon the contract even though he is not a party to the agreement. It is important to note here that the nominees of a life insurance policy do not have this right. Now the fourth one is acknowledgement or estoppel. So if a contract requires that a party pays a certain amount to a third party and he or she acknowledges it, then it becomes a binding obligation for the party to pay the third party. So the acknowledgement can also be implied. Now let us understand this with the help of an example. Suppose A gives rupees 1000 to B to pay C. Now B acknowledges the receipt of the funds to be paid to C, but he fails to pay him. Now C can sue B for the recovery of the amount. Now the next exception is a covenant running with the land. So when a person purchases a piece of land with the notice that the owner of the land will be bound by all duties and liabilities affecting the land, then he can sue upon a contract between the previous landowner and the settler even if he was not a party to the contract. Now the last exception in this case is the contract through an agent. So if a person enters into a contract through an agent where the agent acts within the scope of his authority and in the name of the person, in that case the stranger can also sue the contract, or this is an exception to the privity of contract. Now let us understand a very important thing, that is the main difference in Indian and common law with regard to privity of contract. In England, a stranger to consideration cannot sue. Similarly, a stranger to contract also cannot sue. But in India, a stranger to contract cannot sue, but a stranger to consideration can sue. So this is the important difference in England and India with respect to the privity of contract. I hope you liked the video. We are going to cover many important concepts relating to Indian Contract Act in our upcoming videos. And for other videos, you can check out my playlist. So till then, keep on revising and take care. Goodbye.